Hey there, and welcome to our introduction to McDonald versus Chicago, a 2010 case, which is one of your 15 cases that you need to know for the AP U.S. Government and Politics exam. This is a Second Amendment case that specifically addresses whether or not the Second Amendment right to keep and bear arms is applicable to the states, whether this portion of the Bill of Rights, which had previously been settled by the court a short time before, was applicable to state governments in addition to the federal government. The Second Amendment to the Constitution, which is part of our Bill of Rights, reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, there are two questions about the Second Amendment that for a long time were not answered by the Supreme Court that have been answered fairly recently. The first is, does the Second Amendment guarantee an individual right to keep and bear arms? For a long time, that was uncertain. I know that when I was in school, it wasn't necessarily clearly defined by textbooks because the Supreme Court had never specifically addressed it. This was decided in 2008 in the case District of Columbia versus Heller, in which the Supreme Court for the first time definitively ruled that the Second Amendment does guarantee an individual right to keep and bear arms. Now, since the District of Columbia was part of this case, and this is an area of federal jurisdiction, DC versus Heller did not answer the second of these questions, and that is whether or not the Second Amendment to the Constitution should be incorporated and applied to the states through the 14th Amendment. This is the process known as selective incorporation. Now, let's remind ourselves, we've got a few cases. Gideon is another one of these cases that addresses selective incorporation. There are some parts of the Bill of Rights that the Supreme Court has chosen never to apply to the states. And so this doctrine of selective incorporation really allows the Supreme Court to kind of cherry pick and decide which rights are going to apply to the states. So that is one of the most important takeaways from McDonald, is it does address this issue of selective incorporation of the Second Amendment. So after the Supreme Court in Heller decided that the Second Amendment does guarantee an individual right to keep and bear arms, there were several lawsuits against state and local governments that were filed by people who believed that the laws in those areas were too restrictive, that they limited this right, and a lot of test cases were brought forward. And so McDonald versus Chicago specifically challenged Chicago laws about firearms. And there were a few things here that in particular made it very difficult for somebody to exercise their Second Amendment right to keep and bear arms within the jurisdiction of Chicago. These included, first of all, that it prohibited handguns to be registered, so essentially creating a ban on handguns. Also, it required that a gun had to be registered prior to buying it. So if you were going to go purchase a firearm, you had to register it before you even purchased the thing. Then, once you've registered it, you had to re-register the gun annually, and if you missed your registration, then sorry, you can't register it again. So now that firearm, which you've previously registered, is now illegal. So the people bringing this case forward said that this is undue interference in a constitutional right by a state to keep and bear arms. Now, the question is, remember, this is not about whether the Second Amendment is a constitutional right, an individual right to keep and bear arms, but whether or not the Supreme Court is going to apply this to the states. Now that we've heard the facts of the case, let's go on to the decision. In a 5-4 decision, the majority ruled that yes, the Second Amendment is going to be selectively incorporated and applicable to the states. So the states have to recognize the rights of their people to keep and bear arms. Justice Samuel Alito, writing the majority opinion, said that the Second Amendment is deeply rooted in this nation's history and tradition, that it's a fundamental and deeply rooted right with so much tradition in the history of the United States that, yes, this does apply to the states. Now, we want to remember that there were 4 dissenting justices in this decision from the court's liberal wing. These justices all expressed the belief that the Second Amendment does not represent an individual right to bear arms, and as such, can't be incorporated to the states. Now, this was a dissenting opinion, so we want to remember that the court ruled unequivocally that this is a right that is going to be selectively incorporated to apply to the states, but we also want to note the closeness of this decision, and who knows what might happen later. But as case law stands now, the McDonald decision establishes firmly that the Second Amendment is a fundamental constitutional right, an individual right to keep and bear arms, and that state and local governments are obligated to protect this right. Now, what we want to note is what this decision is not. This decision does not say that state and local governments, just like the federal government, can't pass reasonable regulations that don't fundamentally infringe on a person's right to keep or bear arms. So, for example, if a state were to say that somebody needed to receive firearms training, most states require some sort of training for a concealed weapons permit, for example. So we don't want to mistake this for something that says, well, states can't regulate firearms, because they can. So when we're thinking about McDonald versus Chicago, we want to remember that this is a selective incorporation case, which guarantees that the right of the individual to keep and bear arms will apply to the states in addition to the federal government. And remember, we have a couple of other selective incorporation cases, one of those being Gideon versus Wainwright, which would be a great one for you to look at now that you're finished with this video. I'm glad to help you, and it's always a pleasure.